Hello, this is Matt on the Moon Lambeau channel. Ripple's lawyers have filed a court document sent straight to Judge Annalisa Torres, who is overseeing this whole case, and they have very clearly stated, and quite literally stated, that the SEC's actions have, quote, seriously harmed XRP holders. Now, on that point, I could not more fervently agree. So I'm going to share with you some specifics from this most recent Ripple court filing, which they put out just the other day. They filed just the other day. I also want to share with you some thoughts from John Deaton, who is an attorney who's been filing all sorts of stuff, and I'm sure the vast majority of you at this point are well versed in what he's been doing and familiar with the John Deaton. But for those of you not in the know, he's really bringing the fire. He's actually in the process of filing a class action lawsuit against the SEC, and he's seeking to intervene in the case, the SEC versus Ripple case. And so, the documentation, the court filings that needed to happen to make that occur, it's already been filed. Now we're just waiting to see what the judge, Annalisa Torres, has to say about that. Hopefully, they get to intervene. As XRP holders get to intervene. If not, there's still a path forward. But before I go any further, I want to be clear that I don't have any sort of legal or financial background. I'm not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes YouTube videos as a fun hobby, typically about XRP and Ripple and crypto-related topics and stories. That is indeed all that it is. Just want to be fully transparent on that so that nobody thinks I'm someone or something that I'm not. And I want to start with this. We'll start with the comments from John Deaton, and then we'll launch straight into... Actually, I want to say this, too. There are, in this most recent court filing from Ripple's legal team, there are facts and figures that I'm willing to bet the majority of you listening have never heard before. And I say that with a reasonably high level of confidence because I track this stuff on a daily basis, and there is stuff in here, there's facts and figures that I was unaware of. So it was really interesting. I think you'll find this fascinating. There's going to be a lot of meat to this video. But we'll start right here. John Deaton. And by the way, I encourage you to follow him if you've not yet done so on Twitter. He is at his first name, John, John, middle initial, the letter E, last name Deaton, Deaton, and then the number 1. And so he actually ended up highlighting something from the SEC's most recent filing, which I already went through, so I'm not really going to go through that in this video. Maybe that was from the next Twitter thread. Yeah, it was from the next Twitter thread. This one has to do with what, or maybe this one. I apologize if I got this backwards here. I map out videos, the content I want to put out for the day, and then I usually take a break and come back hours later, so it's not completely fresh necessarily. Like I do a quick review, so I apologize if I get it slightly backwards. But here's the quote that John Deaton highlighted here. Further, the SEC alleges that Deaton and the interveners are only seeking a relisting on crypto exchanges to resume speculative trading of XRP, which the SEC claims is evidence that Ripple Labs offered and sold XRP as a speculative investment. So that was the quote from the SEC. That's correct. And then in all caps, John wrote, "The SEC hates crypto." And so upon reading that, though, it made me think of something that attorney Jeremy Hogan had to say, and this is purely from a legal perspective, because I always say that I invest in XRP, but I could choose a different word. It's just an idea of I'm purchasing an asset for store value, and hopefully it appreciates in terms of price relative to the United States dollar, and it increases in utility. There's a whole number of things that I'm thinking of when I say that. But the term investment itself, it has legal implications. And so Jeremy Hogan, I saw him some time ago within the last couple of weeks, he cited, you might not want to use the word investment as a result of the legal implications of that. And here you see the SEC, they believe that utilizing the word investment does nothing but strengthen their case. And so this idea, again, of XRP, resuming the speculative trading, the SEC actually believes that this is an indication, the fact that the interveners want XRP to be traded, that's some sort of indication that XRP itself is a security, which is completely crazy, obviously. I think that we'll probably all agree on that. And then John Deaton wrote the following. The above statement by the SEC can be applied to every cryptocurrency, including Bitcoin. Speculative trading doesn't turn anything into a security, and it's utter nonsense that's being argued by the SEC. The US government will come after all other crypto if successful against XRP, which is why, and so that's his tweet right there. Now, I just want to say, this is why it's super duper crystal clear to me that if things go very super poorly for Ripple and XRP specifically, if XRP is deemed in its form today to be a security, the asset itself, then what isn't? The entire crypto asset class will be under fire from the United States federal government, specifically the SEC, if that comes to pass. That would be really bad law. So all the innovation, it would just go overseas. It's not that this wouldn't still move forward. It's just like if you tried to ban the internet in the mid-90s, well, the internet would still exist. It's just all the innovation would have happened elsewhere. So instead of having Google, who knows what we'd have? And you can just imagine. And there's so many other big companies that also, there would have been something similar to them developed, certainly. I think that all the promise of the internet, it still would have come to be, but again, it just wouldn't have been here. And so here's the federal government, the SEC, and if they get their way, they're just going to squash it. And that's why John wrote, "The SEC hates crypto." No kidding. And so the Bitcoin maxis out there, they think they're safe. Think again. They can absolutely come after Bitcoin as well. There's nothing legally binding that has been stated by the SEC regarding their position on Bitcoin. If they want to go after it and say that miners, and I think this would be absurd, but if they want to say that miners are putting Bitcoin out into the ecosystem as an unregistered security, they could make that claim. I think it would be nonsense, but they could do it. And so it goes back to this question of who's actually safe here. And then here's another one from John Deaton. XRP holders, you're going to love this line from the SEC's letter. And this is the letter that I covered the other day, so I'm not going to go through the actual letter, but I did want to share some of John Deaton's thoughts on this, but I already went through that just yesterday. But here was a line. If movements want to advance the argument that they are investors, the SEC will make that argument. So you see, there's another indication. Oh yes, they'd love to have it be the case that XRP holders are quote-unquote investors. So apparently that's a naughty word. I don't know if we're supposed to use speculators or what, but we're supposed to use some other term. Otherwise, there's the legal implications, which apparently not favorable. And John wrote the following. The SEC claims if the judge lets XRP holders intervene, she will be forced to allow the XRP investors that sued Ripple in a class action claiming that Ripple sold XRP as an unregistered security. This is nonsense because we aren't arguing that against Ripple. And so what he's saying right there very clearly, I think, is that there are XRP holders, and let's be real, like there can be XRP holders that have all sorts of different viewpoints and perspectives, pro, negative, whatever it is. And so there are those people out there that have bought XRP, and it looks to me like they're just going for a money grab by litigating with Ripple, claiming that Ripple sold XRP as an unregistered security. And those filings happened before the SEC even went after them. But that doesn't align with the interveners. And so John Deaton wrote the following. In fact, we argue the opposite, that XRP is not a security, and therefore, those other investors that sued Ripple have no similar position or interests as us. The SEC doesn't want us in. They want to argue that XRP has no utility even today. They've already said it on the record. And I don't believe for a moment that the SEC believes what they're arguing. Of course, XRP has utility. It's provably so. There are all sorts of developers building on top of the XRP ledger. It's one of the few cryptocurrencies that's being used functionally for anything. And in this case, it's actually used in enterprise-grade software. So if that's not enough, then what the hell? Why are you okay with any aspect of the crypto asset class? And I'm not convinced necessarily that they are. And so then into this is the actual filing from Ripple's attorneys on behalf of Ripple. And I just want to cover part of this. It's 5 pages, but it was just so good to see that Ripple recognizes just how seriously the SEC has harmed XRP holders, despite the fact that the SEC disgracefully is stating that you should effectively, I'm paraphrasing here, but you should look at the cryptocurrency exchanges because it was them that resulted in the price drop, and that's provably not true. I mean, it was something that happened as a result of the SEC filing against Ripple. But as soon as the news of that broke, that's when the price of XRP started dropping, and then more panic set in when the cryptocurrency exchanges felt forced to react to what the SEC did. But anyway, here's what they wrote. The concerns raised by interveners about the lack of clarity in the SEC's theory of its case are well founded. So there you go. Ripple actually, and they cite John Deaton in this multiple times, like they are seemingly, from as best I can tell, very thrilled actually with the argument that that John Deaton has been making on behalf of himself and XRP holders. And so they continue. For more than 8 years, the SEC was content to allow XRP and its associated technologies to evolve from a promising digital asset with superior functionality into the third largest digital currency in the world, after Bitcoin and Ether. And during this time, market participants, including interveners, and so to be clear, that's who John is filing on behalf of, XRP community members, and there's over 10,000 of them that have filed with him, claiming that, hey, the SEC has done messed up effectively. And so during this time, market participants, including interveners, reasonably believed that XRP was a digital asset falling outside the regulatory authority of the SEC. Also during this time, the SEC was content to allow hundreds of companies independent of Ripple to develop products and use cases leveraging XRP or its underlying technology, the XRP ledger. And so this goes back to the whole reason that Ripple's a huge part of their defense is just this idea of fair notice and due process. Just the idea that you can let a company do what they've been doing, and I'm thinking of Ripple here, but there's so many others obviously, do what they're doing. Let all sorts of market participants utilize XRP and the XRP ledger for the better part of a decade, and then go ahead and file and say, even though we didn't know from a legal perspective what we thought XRP was, you should have known years ago that what you were doing was illegal and wrong. That does not pass the smell test. That is not logical. It simply is not. And so Ripple is pointing that out here. And then they continue. As a result, XRP is estimated to be held today, and check this out, by millions of holders worldwide, with approximately $700 billion to $1 trillion in total trading volume since 2013. The SEC included in its complaint conclusory allegations suggesting XRP is always a security and therefore that every offer, sale, or transaction involving XRP is subject to the panoply of regulatory requirements mandated by the federal securities laws. Due to the resulting market uncertainty, XRP has been delisted or trading halted by nearly every digital asset exchange in the United States and by numerous other exchanges throughout the world. The filing of the SEC's complaint resulted in the value of circulating XRP declining by more than $15 billion and the disruption of numerous innovative applications of XRP. And so, by the way, I can't remember which attorney pointed this out, but one of them, within the last couple months or so, they cited that this type of collapse, monetary collapse and devastation, you've never seen this as a result of an action brought against by the SEC against another legal entity, whether it's a business or a person. Frankly, you've never seen this type of financial devastation unless there was a fraud charge attached to this. There is no fraud charge against Ripple. And so this is completely unheard of, completely unprecedented. But nonetheless, the SEC came in like a wrecking ball. Excuse me. And then the filing continues. Based only on unproven allegations, the SEC has effectively shut down trading by XRP holders over exchanges in the United States. And it has done so on the basis of a complaint whose theory of liability is ambiguous at best, and at worst, deliberately misleading so as to arrogate for the SEC optionality as this litigation progresses. Yeah, and unfortunately, and it's not like I enjoy saying this, but I do think it is at the worst. Deliberately misleading, yup. And I think that they're being disingenuous with the way that they're going to trial here, but I get it. They're going to try and make every legal argument they can and just see what sticks, but it's not honest, it's not truthful, it's not ethical. That's just how they're behaving. That's how I see it anyway. Ripple's lawyers continue now. Interveners highlighted the ambiguity in the SEC's complaint and filed suit in Rhode Island asking the SEC to amend its complaint against Ripple to exclude present-day XRP purchased by investors with no connection to Ripple or its executives. And so they're talking about the petition for writ of mandamus. And the SEC refused. And as a result, interveners voluntarily dismissed their suit in Rhode Island and now seek relief here. Recently, Judge Netpern rightfully identified the same ambiguity and asked the SEC whether its position in this case is that, quote, every individual in the world who is selling XRP is committing a Section 5 violation, end quote. The SEC did not dispute the premise of her question, responding ambiguously that, quote, speaking very generally, end quote, non-parties XRP transactions would likely be exempt under Section 4 by invoking the Section 4 exemption, which only applies to a security subject to registration under Section 5. The SEC essentially confirmed that. And so I know that's a lot. It's a lot of gobbledygook probably to people that aren't lawyers. And so here's the nuts and bolts of it, though. Here's what they write. Regardless... So the SEC essentially confirmed that regardless of the seller or circumstances of the sale, XRP is, in its view, per se, an investment contract and therefore a security per se. And so there are lots of people that that took the comments of the SEC, which were intentionally vague, as some sort of indication that it is indeed okay for exchanges to start trading again, this or that. And with me not having a legal background, there's no way for me to have my own stance on this. All I can do is take in the information that I'm getting from the lawyers that are willing to talk about this. So here, all I can share with you is that Ripple's lawyers do not think it's the case that there is sufficient clarity as a result of what the SEC attorney, Jorge Tenrero, that was his name, regardless of what he said there, which is what prompted, frankly, the relist XRP hashtag, and that's what got it trending. Despite that being the case, Ripple actually, their attorneys here, they're clearly stating that they don't think that it's sufficient to provide clarity or confidence for anyone, even outside of Ripple, that the XRP you hold is not a security. It's just not there. And so the attorneys continue. That premise, if accepted, would empower the SEC to regulate vast numbers of... sorry, I just lost my spot. I just scrolled down and then I was looking, how does this happen to me? There we go. That premise, if accepted, would empower the SEC to regulate vast numbers of non-parties, including digital asset exchanges, vendors, and retail holders. My friends, that's you and I, retail holders. That is you and I. This directly threatens the interests of interveners whose ability to transact in XRP could be impaired, even though there is nothing about their conduct that could plausibly make XRP an investment contract and thus a security in the context of this litigation. So look, from a logical perspective, it follows. From a legal perspective, we'll see what happens, who ends up winning, and what legal arguments hold weight in court. From a logical perspective, you can speak as a layperson, and I'll speak for myself here. The logic follows. I don't see how it's possibly rational to consider that the XRP that I hold, when I don't have a contract with Ripple and I'm not relying solely on Ripple to increase the price of XRP, given that's the case, how could it possibly be that the XRP that I hold represents an investment contract with Ripple? There's no way it does. It does not pass the logic test. Yet, here we are. So thanks for nothing, you bunch of asshats at the SEC, ruining everyone's birthday. All right, I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a bad, bad, bad idea. Until next time, to the moon, Lambo.